Good morning. My name is Daryl Krause, and I'm an attorney here at Bauman Law. I want to talk to you today because you're scheduled to have a deposition in your case. I wanted to give you some general information about your role as a witness during the deposition. The purpose of a deposition is to allow the parties to determine the facts of the case prior to trial. Because your deposition is taken under oath and can be used at trial, it's important that you be certain of your answers, that you not volunteer information and not speculate on matters which you have no information. In view of the fact that your deposition could be presented to a jury, it's also important that there be as little hostility displayed on the record as possible. Something that is said, which may appear innocuous when said, can be devastating when it's read by someone else to a jury, which does not have the time or the ability to judge the demeanor of the witness. Also, because a deposition is being taken down by a court reporter who cannot take the testimony of two people at the same time, it's important that you make certain the person asking the question has completely finished their sentence before you respond. This avoids the possibility of an erroneous answer to a question. For example, if the attorney says, "Are you dead or are you alive?" and not waiting for the second part, the question, you answer yes. When the complete question and answer are typed, it will appear as though you stated you were dead. It is also important to wait for a few seconds after the question's been asked so that if there is an objection, your attorney can interpose that objection before you answer the question. Another purpose for your deposition is to freeze your story. In the event that you were to testify at the time of trial in any way that was different from your testimony during the deposition, the other attorney would be able to use the deposition to contradict and embarrass you by showing the prior inconsistent statement. This is what lawyers call impeachment, and it's very effective in front of a jury, as the jury is inclined to not believe a witness that changes their story. So in order to help you prepare for your deposition, you need to understand there's a great difference between a deposition and a trial. The deposition is a one-sided affair, and it will seem that it favors the other attorney. The other attorney is asking all the questions, and you are under a general obligation to answer all of the questions. Even though some of the questions certainly will not be permissible at the courthouse during trial, these questions do not have to be directed toward admissible evidence. The attorney has wide latitude in asking any questions during a deposition. This is to permit adequate discovery and pretrial preparation by both that attorney and yours. No judge will be present to rule on any objections at your deposition, and your attorney will be playing a pretty limited role that day, and it's crucial you remember that. Your attorney will be listening to each and every question that you're asked. If any of them are improper, your attorney will object. However, do not anticipate a large number of objections. It may be that there are none. And I don't want you to misconstrue your attorney's silence as a failure to protect your interests. Next, I want to give you some information that will assist you in knowing what the opposing attorney is attempting to do while they're asking you questions. As I mentioned before, the attorney has more than one reason for taking your deposition. The form of his questions may reveal to you their major interest. When they're asking questions primarily for discovery purposes, just to obtain information, the questions are going to be broad and the subject far-reaching. They're trying to encourage you to give rambling answers that might reveal new facts. If the attorney is attempting to elicit information from admissible evidence, things that he can read right to the jury at the time of trial, questions will be more sharply focused. When he's doing this, the attorney is trying to freeze your testimony. You will be repeatedly asked, was there anything else? Is that everything you remember? Forcing you to commit yourself to a position that you cannot amend or correct at the time of trial without risking impeachment. The attorney will probably ask you many leading questions. A leading question is one that is really just a statement of facts which only the deponent is asked to agree or disagree. The attorney may ask you things to which they want a yes or no answer, and the attorney is going to try to put words in your mouth through that process. And if any part of the leading question is incorrect, do not answer yes, and make it clear by your answer that you cannot completely agree with the statement that was made. The attorney will probably ask you why, restate it including the correct fact, and again ask you to agree or disagree. Remember, they're trying to freeze every detail of your testimony. Make sure it's correct before you agree with the statement. They're also going to be trying to get responsive answers from you. In other words, they're going to want a clear yes or no. The attorney will probably ask you the question in several ways to get a response. Additionally, they are going to be watchful for prior inconsistent statements. However, if they notice one, they probably won't mention it during the deposition, but save that for trial. And it's probably that the other attorney's first step in the deposition will be to create a record that can be used at trial and show that you understood the full nature of the deposition and all of the uses for which it could be put to. Basically, the attorney is trying to protect themselves if at trial you insist that a contradictory statement was caused by your failure to understand what was going on at the deposition. So after the attorney establishes that you understand the deposition, that you are under oath, and that the deposition can be used at trial, and that your testimony during the deposition is subject to the same penalties of perjury as testimony at trial, they'll proceed with the questions. Typically, the attorney will ask a lot of demographic questions, such as your name, address, age, family background, where are you from, what high school you went to, the names of your spouse, the name of your spouse, family members, etc. These are meant to get you in the habit of answering and to get you to think about things that isn't so tough. Don't let your guard down. The attorney will probably proceed in a chronological fashion, starting with the oldest information to the latest information. And I expect they will go into great detail on your education, training, employment, driving record, etc. And with regards to questions that ask you about the specific incident in question in the lawsuit, the questions are going to be meticulous, redundant, and exhaustive. Not all the questions will seem relevant, though, and not all of them will be. Not all of the questions may even be intelligent, because attorneys are people, and while they're thinking ahead about what questions they're going to ask, sometimes attorneys get lost in the weeds with a rambling, seemingly incoherent question. Your attorney will, of course, object to the form of the question, but don't hesitate to point out to the other attorney that the question makes no sense, and please rephrase the question. A jury can be influenced by your emotional reactions, and it's undoubtedly in your best interest that the jury hear your testimony to find you a credible, sympathetic, and someone who they can relate to as a human being. Remember that pauses will not show up on the transcript. Therefore, take your time to think before you answer. If a question is unclear or you do not understand it, ask that it be repeated. If a question is really a compound question, your attorney will object to the form of the question, but in case your attorney doesn't, make sure to ask the other attorney to rephrase it into separate questions. Let me go through some basic rules for your role as a deposition witness. Number one, tell the truth. You must always follow this rule. You should not interpret anything else to be at odds with this rule. You will undoubtedly encounter questions that we have not covered today. When that occurs, do not get upset. Focus on the question, and if you can, answer it. You may be asked if we met to prepare for the deposition. Tell the truth and say, yes, you did meet with your attorney, but you don't have to reveal what that conversation what the conversation was, because that conversation is attorney-client privileged. But all lawyers know better than to ask about your conversations with your attorney. But even if they do, your attorney will instruct you not to answer. Number two, listen to the question. Concentrate on every word. Wait until you hear the last word of the question before you start your answer. If you listen closely to ordinary conversations, you'll see that we cut each other off quite frequently. And it's not meant to be rude, it's meant to keep the conversation flowing. Listening is hard work. If you listen as you should, you'll be tired at the end of the day of your deposition. Rule number three, make sure you hear the question. If the attorney drops their voice, someone coughs, the remote deposition sound goes awry for a moment, and you miss a word or two, say you did not hear the question and ask for it to be repeated. Do this even if you are almost certain that you know what the word is that you missed. Rule number four, make sure you understand the question. Sometimes the question will be so long or so convoluted, you won't even know what was asked at the beginning, except that it relates to a motor vehicle accident. And you may be tempted to just say anything about the motor vehicle accident in the hope that the other attorney will go on to something else. Do not do that. Just say, you do not understand. If you do not understand, do not help the other attorney in asking the question. Do not say, well, if you mean this, then my answer would be such and such. Or if you mean that, my answer would be so and so. You may very well give the other attorney ideas that they never had themselves. Every word in your answer could lead to a new question. Say only that you don't understand the question. Rule 5, answer the question. After you've listened to, heard, and understood the question, then answer the question. Some lawyers say if you're asked your name, you should give your name but not your address. Other attorneys say that 95% of the questions can be answered yes or no, I don't know, or I don't remember. Those questions maybe go too far to make the point, but generally you should keep your answer short and to the point. Remember, every word in your answer could be the seed for a new question. I often advise clients to remember, if your answer is going on for more than a minute or 2 minutes, you've probably answered more than you were asked. Always answer yes or no, not uh-huh or and nodding or shaking your head, because the court reporter may misinterpret what your answer is and they cannot take down body language. Do not volunteer information. Be straight and precise about your answer. Once it's been said, it can't be unsaid. If you don't know or do not remember, just say that. You do not get extra points for guessing. If you're pretty sure of the answer but not 100% certain, say that. It's fine to say, I don't know the answer to that question, or I don't remember exactly, it happened so long ago. And it's perfectly natural to forget minor details. Just do not guess or make something up. Be careful of making absolute statements such as nothing else happened unless you're 100% sure that statement is correct. If it's a time or a distance question and you aren't sure, say that. If you are asked to approximate, make sure you preface your answer with, don't know exactly, but the time was between 8:30 and 9. Only answer a question from the facts that you know personally, what you yourself saw or heard, not what somebody else told you. What you learned in taking tests in high school and college also applies here. Answer the question you were asked. If a question begins with who, your answer should be a name. If the question begins with where, your answer should be a place. If the question is when, your answer should be a date or time, and so on. If you do not know or remember, just say that and keep quiet. Don't volunteer reference to a document such as, I don't know, but if I check my calendar at my desk. You may be asked the same question later in the deposition, but phrased in a slightly different way. Be consistent with your answers. You do not get extra points for giving perfectly clear and complete answers. Normally, if there's some ambiguity in your answer, that will be a problem for the other party, not for you. Sometimes after you give your answer, there will be silence. The other attorney will be thinking how to word their next question. Silence can sometimes make witnesses uncomfortable, and you may be attempting to fill the silence with words or volunteer information. Do not do that. Keep quiet, wait for the next question. If a question irritates you or makes you angry, resist the temptation to argue with the other attorney. If you get into an argument with the other attorney, you will lose. It's not a personal attack. Be careful of the lawyer baiting you into losing your temper. Stay cool and collected. Just give whatever facts you know, responsive to the question, and then keep quiet. If you feel like you're losing control or your temper, ask to take a break. Just make sure you answer the question that's on the table already to be answered. If you are asked a question that requires a long answer, give it. Use your common sense. If you are in doubt, keep your answer short or ask the other attorney to break down the question into subparts. Do not make speeches. Remember, every word you say is another target for the opposing counsel. In dealing with the other attorney, your manner should be courteous and open, but mentally you should always be on guard at all times. Even if something is said off the record, the other attorney can ask you about it when you're back on the record. Your attorney may object to certain questions. When you hear your attorney's voice, stop talking. Try not to be distracted by the objection. Listen to it. It may point out some hidden trap in the question. It also may be that your attorney is just trying to interrupt the other attorney's rhythm. The objection is also a reminder to you to keep concentrating. Your attorney may go further and instruct you not to answer the question, and if you do, follow that instruction, because it may get your attorney in trouble in court, but it won't get you in trouble. You will not be in trouble for that. Rule number 6, stick to truthful answers. You may hear the question more than once, and if your original answer was accurate, stick to it. The fact the other lawyer keeps coming back to the question does not mean you are answering incorrectly. You must give the facts as you know them. If you give the facts right the first time, stick to your answer. Of course, the other lawyer is an experienced and skillful questioner, and through their questions may try to create doubt in your mind, even about facts that you know very well. For example, this has nothing to do with your case, but suppose he shows you a coffee cup and asks you, "What is it?" You say, "Well, that's a coffee cup." But then the attorney pauses, gazes at the cup, and kind of lets you squirm. Then after letting you wonder what he knows that you don't, He leans forward and says, "Now, Mr. Witness, is it your testimony here today, under oath, that this is a coffee cup? Do you really mean to say that?" There's a natural tendency to back off and say, "Well, I thought it was a coffee cup." That small change in your testimony may be crucial. Suppose a witness says the first time that they had the green light, and then says he thought he had the green light. That would be a devastating change. So if your answer was true, stick to it and say, "Yes, that's a coffee cup." What does the other lawyer do then? They'll go on to another subject quickly when they see you cannot be shaken. Of course, if you realize that your earlier answer was in error or incomplete, correct or supplement it. Obviously, you should not say that your earlier answer is true if you became aware that it is not. So follow these suggestions. Don't be in a hurry to answer, and you will be a great witness at your deposition. If you have any questions, give your attorney a call, and thank you for being a client of Baumann Law.